Here. Hi, everyone, and welcome to our program. Before we get started, those of you heard me say this before, but we're holding our annual reception on November 9th at 6 p.m. Eastern. This year will be virtual, and we are honoring the New York State Attorney General for her work in support of nursing home residents and families. And we're going to have a really, I think, special program with Carmen Bowman, who does a lot of work on changing the culture of nursing homes with resident-centered and resident-focused and resident-directed activities and care. So that should be really good. And we have a special guest, Bridget St. John, who will be providing, a mini concert for us. And here you can register. You can go to nursinghope411.org/LTCCC12. I think that's it. Yes, thank you. And then a few introductory points before we get started. One, if you have any questions for our speaker today, please put them in the Q&A. You're welcome to use the chat for discussion or comments. But if you want to have a question, we're gonna leave time at the end. If you have a question which you would like responded to by our speaker today, please put it in the Q&A. A little bit about LTCCC, for those of you who are not familiar. We are a nonprofit, nonpartisan organization entirely dedicated to improving care and quality of life for residents in nursing homes and assisted living and other residential care settings. We do most of our work is in respect to policy research and analysis on long-term care, on issues that affect residents' well-being and dignity. And based upon that research, we do a range of systems advocacy on both the state and the federal levels. More and more over the past 10 years or so, we've been doing public education, such as these monthly programs. We also have an excellent podcast and other materials on our website. We'll talk a little bit more about them later on. And we are also the proud home to 2 local long-term care Amazon programs in the Hudson Valley of New York. Without further ado, I want to hand this over to our special guest speaker today. I'm really excited to have her. Our speaker today is Meryl Grenadier from the AARP Foundation Litigation. Pardon me, that's my dog Zelda, who is barking in the background of all times to do this. Meryl is going to talk about enforcing the Nursing Home Reform Act. And the reason why I first thought to invite Meryl to come speak to us is because AARP Foundation Litigation has done just some tremendously important work over the years on both the national level and in a number of states to support residents' rights and to support good quality of care and accountability. So I've been really excited and pleased to partner with them at times over the years and to support their work in any way that we can, and to feature Meryl today. A little bit about Meryl. She is an attorney, again, of course, at AARP Foundation Litigation. Her work involves nationwide impact litigation and legal advocacy on behalf of low-income adults. For those of you who are not familiar with the terminology, impact litigation means filing a lawsuit that is with the hopes that it'll have a broad impact on how care is provided or other issues relating to seniors and adults in facilities and out of facilities. Meryl works on matters involving health law, civil rights, elder abuse, retirement benefits, and consumer protection. Before she joined AARP, she was an associate at a DC boutique litigation firm where she worked on matters including whistleblower actions, consumer class actions, and commercial disputes. I actually went to law school so I wouldn't have to do litigation. I went to law school in DC so I wouldn't have to do litigation. So that's very interesting. Now, I am doing Meryl's slides, so if you'll give me a second, hopefully this will work out. I just need to transition from my slide deck to Meryl's. Just one second. Here we go. Play from the start. So enforcing the Nursing Home Reform Act. Meryl, I'm going to turn it over to you and I'm going to stop my video.
Thanks, Richard. Thank you so much for that wonderful introduction, and to you and to LTCCC for having me here today and for putting together all of these really informative programs. Can turn to the next slide, please. And I don't know if the closed captioning is on.
Oh, let me,
I suspect.
sorry about that. It has two different settings for the size. Sorry about that.
Yeah. There
works.
we go.
Thank you for
I
noticing.
see it now. Okay, so this is just a little bit about AARP Foundation. We work to help older adults build economic opportunity, focusing on achieving equitable outcomes for those that have historically faced systemic discrimination. Like Richard said, I'm from our litigation unit, and so we bring cases and file friend of the court briefs in federal and state courts nationwide to work towards the goal of ending senior poverty. Next slide, please. So what we're going to cover today, we're going to go over just some of the basics of the Nursing Home Reform Act, and then we're going to talk about recent litigation and decisions that relate to enforcement of the Nursing Home Reform Act. In particular, National Consumer Voice versus Becerra, which is a recent case that I worked on, and then some decisions concerning private enforcement. And like Richard said, then we'll have some time for questions at the end, so you can put those in the chat. So starting with the Nursing Home Reform Act, can go to the next slide. This is a federal law that was enacted in 1987 as part of the Omnibus Budget and Reconciliation Act. And that just means that it was part of a big budget package that was passed in that year. And it was in response to a study that had been done by the Institute of Medicine, commissioned by what is now called CMS, what was then called the Healthcare Finance Administration, that was supposed to serve as a basis for adjusting federal and state policies and regulations governing the certification of nursing homes, so as to make those policies and regulations as appropriate and effective as possible. And at that time, there had been discussion in Congress about how to regulate nursing homes. And there were people on some side that said less regulation, and the other side that said more. And they said, why don't we commission a study? So that's what happened. And the report, which is linked in the slide, has some key findings. Notably, that government regulation at the time of nursing facilities was failing. There were too many substandard facilities that were allowed to remain open. And there was documentation of just really horrifyingly bad care of residents, including abuse and things that resulted in injuries, death, increased disability, and unnecessary fear and suffering. There was also just general reports of poor quality of life. Residents were disrespected, denied food choices, denied roommate choices, not allowed to choose when they slept and woke, what clothing they wear, what activities they did, things like that. And so the conclusion of the report was that stronger regulation of nursing facilities was in fact needed. And in some ways, it feels like a little bit like the present moment, where over the last couple of years, we've seen some of the places where nursing facility regulation really could be improved. And so the law sets requirements for nursing facilities to follow and establishes, minimum resident rights. You can go to the next slide, please. And this is from the statute, and it provides sort of an overview of what the law is supposed to do. Provide services and activities, or nursing facilities are supposed to provide services and activities to attain or maintain the highest practicable physical, mental, and psychosocial well-being of each resident. We can go to the next slide. And so what is actually in the law? And these are sort of the sections that the law breaks out to. I'll just go over each of them briefly, but provision of services. So what does a nursing facility have to do? And some of the key things in that section talk about coming up with an individualized care plan for each resident upon their admission to a facility, based on an assessment of that resident and in consultation with the resident and their family or legal representative. And that be updated, when there's a change in the resident's condition or annually. Resident rights, that the facility must protect and promote the rights of each resident. And we're going to go through some of the specifics of that when we get to the next slide. Administration, other matters, how the nursing facility has to run its business, that it uses its resources to ensure that residents do live the highest practical quality of life. It also requires infection control programs and certain requirements, requires compliance with certain federal and state professional standards. State requirements are things that the state must do with respect to nursing facilities. Responsibilities of the Secretary of CMS. This is just to ensure that the requirements and enforcement of them are adequate to protect the health, safety, and welfare of the residents' rights. There is a survey and certification process, which we're going to talk a little bit more about, but this is the process for determining whether a nursing facility is actually in compliance with the statute and regulations. And then enforcement, so how compliance is actually ensured. We're going to address that in more detail as well. And then Nursing Home Compare, which is now called Care Compare, which is just a website, a repository where there's publicly available information about nursing facilities. So you can find information about health inspection, staffing, quality of resident care ratings, and penalties that have been assessed over the last 3 years. The next slide. And so these are the enumerated resident rights in the statute. And the statute says a skilled nursing facility must protect and promote the rights of each resident, including each of the following rights. And so free choice refers specifically to choice of a doctor, the ability to be informed and participate in decisions about the resident's own care and treatment. Free from restraints, this refers to the right of residents to be free from physical, mental abuse, corporal punishment, involuntary seclusion, and any physical or chemical restraints imposed for purposes of discipline or convenience. Privacy, the right to privacy in their accommodations with respect to medical treatment, in their written and telephonic communications, and in visits and meetings of family and resident groups. Confidentiality goes hand in hand with privacy, but residents are entitled to confidentiality of their personal and clinical records, as well as access to those records upon request. Accommodation of needs, so just reasonable accommodations of the residents' needs and preferences. They're supposed to get notice of any changes to their room or their roommate, if that's applicable. Grievances, so the statute talks about the right to voice grievances regarding to treatment or care, and not face discrimination or retaliation for reporting those grievances. Activities, the resident has the right to organize and participate in groups, as well as any social, religious, and community activities. There's also a right to have visitors. Examination of survey results, a right to look at those results of a survey that's performed by a regulator upon request. Refusal of certain transfers, so within the facility, and there are also separate enumerated rights with regard to transfers and discharges out of a facility. And then I put this in bold because it says any other right established by the secretary. And so these rights that we've gone over are really just the floor, not the ceiling. And so many states do have, their own rights that are more expansive than these. And the other thing that's important about this is that the facility is required to notify the resident orally and in writing at the time of admission of these rights. Now I can go to the next slide. And so a little bit about the survey and certification process. So this is the process by which the government determines whether a nursing facility is in compliance with the Nursing Home Reform Act. And so this is a shared federal and state responsibility. And what that means is that typically the federal government contracts with a state agency to perform the surveys. And an annual survey is supposed to be done. And there are other types of surveys that may occur more than annually. So for example, if there's a specific complaint or some kind of incident, it might be more often than annually. Or for example, during COVID, we saw there were, specific infection prevention surveys, things like that might come up from time to time. And then the state surveyor is going to recommend an enforcement action. This is with respect to federal penalties. And then CMS is responsible for imposing the penalty. And when I say penalty, really, I guess I mean remedy, and I'll talk a little bit about what I mean by that. So we're again talking just about government enforcement here, and the remedy for when a nursing facility is out of compliance is supposed to be based on the nature, scope, severity, and duration of the identified deficiencies. So there's a range of available remedies that are meant to, track roughly what the deficiency is. And so in the most serious cases, when a resident's life is placed in immediate jeopardy, the statute allows for termination of the facility's participation in the Medicare Medicaid programs. So that is a particularly harsh remedy. They can also deny payment for a particular resident. They can assess a civil monetary penalty, which we're going to talk about. They can appoint temporary management, and they can close the facility and or transfer residents. And so I'm going to talk just a minute about civil monetary penalties, because that's going to be important in the next section of the presentation. And what the statute actually says about civil monetary penalties, these are fines, is sort of a common way of describing them. And the statute actually says a civil money penalty assessed and collected with interest for each day in which the facility is or was out of compliance with a requirement of subsection B, C, or D. So if a facility is out of compliance, the statute says a penalty or a fine should be assessed for each day that you were out of compliance. So an example might be if a resident was supposed to receive a particular, a pressure relieving mattress as part of their care plan. For each day that the resident did not receive that mattress, say it was 30 days, the facility would be fined each day. And that fine would add up and be rather significant. So just keep that in mind. And much like with the resident rights, these remedies are also the minimum. So states and CMS can develop additional remedies. And after the law was passed, CMS in fact did do that. They developed something called a per instance penalty. So what I just described was a per day penalty, but here what CMS said was sometimes we can't tell when the violation started, for example, or when it was fixed, because the surveyor is only going in once a year and isn't always going to be able to discern that information from medical records or things that are on file. And so in those instances, you could have a one-time fine just for the deficiency as a whole, regardless of how long the deficiency had gone on for. And the other thing about enforcement, just to note, is that there are processes for nursing facilities to appeal and to dispute enforcement actions. And oftentimes they do, and sometimes those fines are reduced or they're implemented as assessed. All right, we can go to the next slide. So I want to talk about a lawsuit that we brought this year that deals with enforcement of the Nursing Home Reform Act. So you can go to the next slide. So the Administrative Procedure Act is a statute that governs how federal agencies develop and issue regulations. It provides an avenue for people to file a lawsuit against a federal agency if they've been adversely affected or aggrieved by an agency action. So this case was an Administrative Procedure Act case, and it had to do with one piece of the enforcement structure, which is guidance that was issued by CMS in 2017 relating to fines assessed for instances of past non-compliance. And so that is a situation where the facility failed to meet the requirements of the Nursing Home Reform Act. So they failed to do something that we just talked about for some period of time, but they fixed it before the survey came. And one thing I'll say about that is that sometimes, you know, the surveys are supposed to be surprise surveys. The facilities are not supposed to know about them, but oftentimes they have information or they know when a survey is coming. And so they're able to quickly fix things and make the facility seem more in compliance than perhaps it was the week before. And so this surveys happen one time a year. So, you know, you can imagine something that was out of compliance maybe for 363 days. But if it gets fixed before the survey, it's considered past noncompliance. And so we represented two advocacy organizations, the National Consumer Voice for Quality Long-Term Care and the California Advocates for Nursing Home Reform, both groups that advocate for residents' rights and that do a lot of work directly with residents to resolve complaints and issues in their nursing facilities. And we sued the Secretary of Health and Human Services and the Centers for Medicare and Medicaid Services, the agency that actually issued the guidance. Next slide, please. I'll tell you just a little bit about what we challenged. So when we talk about the survey and certification process, starting in 2007, surveyors, you know, across the country would go into facilities and they have, you know, a checklist of things they're supposed to be looking for. And there's something called the CMP analytic tool. And that is basically a worksheet that surveyors can use to determine what an appropriate penalty is for a deficiency they observe. And so from 2007 to 2014, that analytic tool, which helped them calculate the penalty, existed but was not publicly available. So no one really knew how they determined what the fines were. It was just that they had some way of determining them. In 2014, the tool is made public for the first time, and it's made public, and the goal of making it public, the announced goal at the time, was to achieve uniformity in issuing fines. So, you know, CMS is broken into regions, and there were, you know, complaints from industry that, you know, a nursing facility in California was not getting fined the same amount as a nursing facility in Kansas. I just picked those states at random, but that's sort of the idea that, you know, for the same violation, these facilities should be fined the same amount. And so the tool was public, and for past noncompliance, the default fine was a per day fine. So in that example of the resident who needed a special mattress, it would be the 30 days that that resident did not get the mattress, a fine would be assessed for each of those days. Then a couple of years later, we get something called the Federal Civil Penalties Inflation Adjustment Act. And this law is important to this story only because it applies government-wide. So it is a law that is meant to adjust any kind of regulatory fines for inflation so that they actually have teeth, so that they're not just the cost of doing business, so that they reflect real costs and have a deterrent effect on whatever industry the fine is being assessed against. But in 2016, that was the first time that the inflation adjustment was actually applied to nursing facilities. That was the first time the fines for nursing facilities had been adjusted in 25 years. So there was a big jump on the actual amount of fines. And then in March of 2017, we actually had you know, a new administration, and we had a new secretary of HHS, and the American Healthcare Association and the National Center for Assisted Living. These are two groups. These are the big industry groups that represent the interests of nursing facilities and assisted living facilities. They sent a letter, you know, congratulating Secretary Price on his confirmation and saying, you know, one really big problem are these CMP fines. And this is a quote from the letter: "The use of CMPs is out of control. They specifically asked for a reduction in CMPs. And in July of 2017, they got what they asked for. And so CMS issued a policy memo that revised the CMP analytic tool to expressly make the default for past noncompliance a per instance fine. So in that example that I talked about of the resident who did not get her mattress for 30 days, it would be one fine instead of 30 fines added together. Next slide, please. And so this is the actual language. This is the citation at the bottom here to the policy memo, but it says ROs, which are CMS regional offices, will impose a per instance CMP for past noncompliance. And, it's also, and then this is another quote of just reiterating the same thing. Next slide, please. And so what was the effect of this policy change? It basically wiped out the state surveyor's discretion. So when I read to you from the statute earlier that said the fine shall be per day, that essentially meant nothing for the state surveyor anymore because it wouldn't be imposed. And then it also cabined the discretion of CMS regional offices to consider a per day fine in certain cases. And of course, like I just said, it's contrary to what Congress expressly authorized in the statute. And then it was also in conflict with CMS regulations that authorize CMS in the states to impose per day CMPs. Next slide, please. And the impact, as you can imagine, is that it decreased the dollar amount of penalties assessed for past noncompliance. It made past noncompliance, just a slap on the wrist, something not to really worry about. It encouraged facilities to allow deficiencies to linger unaddressed until right before the next survey. And past noncompliance is one piece of the enforcement system, but when you start to weaken one piece of the enforcement system, it sort of has an effect on the rest of the system. We did see in some cases that per instance fines also became the norm in other contexts, not just past noncompliance. And with respect to the clients that we represented, it increased the workload for advocacy groups who, have a reliance on a robust enforcement scheme. So they fielded more complaints and, there was no real backstop or threat of fines to sort of counter poor care and things that were happening in facilities. And of course, residents are at risk. We're at risk of poor care and dangerous conditions that were left to continue. Next slide. And so what did we do about it? So we first sent a letter to CMS asking them to withdraw the guidance, sort of laying out, the reasons why we thought it was inconsistent with the law. And National Consumer Voice and Canner advocated against the policy change, as did many, many others. And CMS actually wrote AARP back and said, you know what, we got your letter, but this is a really small percentage of fines, and sort of didn't really address the concerns we'd raised or offer to retract the guidance. So that was obviously insufficient for us. And so in January of this year, we filed our lawsuit. And immediately after we filed, there was a change in administration, and the agency requested time to reconsider the policy memo that had per instance penalties as the default. And then in July, after some negotiation back and forth, the agency let us know that they were rescinding the policy. And so we can go to the next slide. And so this is the actual language that that went up on CMS's website where the policy memo used to live. And so it says, we're removing the July memo. And it says, upon further consideration, CMS has determined that the agency should retain discretion at this time to impose a per day penalty where appropriate. And so, this was great. This was a really positive step in the right direction, that now state surveyors can recommend and CMS can impose per day penalties for instances of past noncompliance. And that means that stiffer fines can return in cases where it's warranted. But, there's still a little bit of confusion about what this means in effect. So, in the CMP analytic tool itself, it still says that the default is per instance for past noncompliance, but it says that the surveyor can contact CMS to talk about whether a per day penalty should be imposed. So it's a little unclear, and there's definitely still some work to be done in terms of monitoring what kinds of fines are issued going forward. Next slide, please. And that brings us to private enforcement. So up to this point, we've been talking, about the government enforcing the Nursing Home Reform Act. And, government enforcement is great to make sure nursing facilities comply with the law. But, as the Institute of Medicine found, back in 1986, and as a lot of advocates recognize now, it's not perfect. And it certainly doesn't compensate individuals when their rights are violated or when they're harmed. And so that's where, a private right of action, a private lawsuit can come into play. And so just some examples of, where government enforcement breaks down a little bit. In 2016, more than 1 in 5 nursing facilities received a deficiency for causing actual harm to a resident. And in 2019, a GAO report found significant gaps in oversight of nursing facilities when it came to instances of abuse and neglect. That report also found that nursing facilities were way under reporting instances of abuse and neglect, even though they have requirements to do so. And so how do you bring a private lawsuit to enforce your rights as a nursing home resident? There is a statute, 42 USC 1983, which authorizes lawsuits against state actors for violations of federal rights. And I think what's important about this to understand is just that not all federal laws create a federal right that you can go into court and sue to enforce. And this is just the federal law. So many states do have their own resident bill of rights. Some of them specifically state that they're privately enforceable. So for example, in California and Illinois, those are 2 states where you can sue in state court, but here we're just talking about federal court. And so there is a test to determine if a statute like the Nursing Home Reform Act creates a privately enforceable right. So first, whether the plaintiff is an intended beneficiary of the statute. Second, whether the plaintiff's asserted interests are not so vague and amorphous as to be beyond the competence of the court to enforce. And third, whether the statute imposes a binding obligation on the state. And then after this test, there's other analyses, whether Congress expressly said, actually, you can't sue about this, or if it's implied for other reasons. Next slide, please. And so there are 3 US courts of appeal that have held that the Nursing Home Reform Act is a rights creating statute. Grammer, Anderson, and Talevsky. And I want to be very clear about this. It's a rights creating statute with respect to nursing facilities that are run by the state. And so it is increasingly common actually that a county or a state will actually own the nursing facility and sometimes farm out, running it to a private entity. All 3 of these lawsuits are lawsuits against a state actor. So you can't use this in all circumstances, but there are a large number of nursing facilities that you can sue using this theory. Next slide. So the first case is grammar, and this case involved the plaintiff was a resident's daughter who sued a county-run skilled nursing facility and rehab center, and the daughter alleged that as a result of the center's failure to provide proper care, her mother developed ulcers, became malnourished, and eventually developed sepsis, which caused her to pass away. So it was a wrongful death lawsuit. And the court looked at that three-part test and found that there was no question that Grammer's mother was the intended beneficiary of the Nursing Home Reform Act, that someone who was a resident of a nursing facility would be a beneficiary of that law, that the rights included in the Nursing Home Reform Act are clearly delineated. So, providing proper care, providing proper nutrition, things like that, those are obviously laid out in the statute. And that the act unambiguously binds the state and state-run nursing facilities to do what is required. And that looked at language in the statute, like a nursing facility must protect residents' rights, must provide proper care. All of those types of words are important to the analysis. And so this was the first case that allowed someone to go forward. And ultimately, the daughter ended up, I believe, settling the case before trial. I don't know what the amount was for. I can move on to the next one. Next one is Anderson v. Galley. This was a lawsuit brought by two residents and an advocacy group against the California Secretary of the Department of Health and Human Services. And so each of the residents in this case alleged they were dumped, which is a practice where the nursing facility sent them to a hospital under the guise of some kind of emergency situation, but then refused to readmit them once they were cleared to return to the facility. And I understand there has been a prior presentation from LTCCC about this, but unfortunately it's a rather common practice. And this case is a little different because it's not a direct lawsuit against the nursing facilities. It's a lawsuit against the state of California. So the Nursing Home Reform Act requires there to be a mechanism for residents to have a hearing when the facility, gives them notice that they're going to evict them. And these residents actually won their administrative hearings. So they got decisions that said, actually, there's no reason why you should have to leave the place that you're living, and the facility should take you back. And they need to, hold on to your bed and give you notice. And the facilities didn't let them back in. And so the court ultimately held that the provisions of the Nursing Home Reform Act requiring states to provide a mechanism for hearing appeals on transfers and discharges creates a statutory right enforceable under Section 1983. And the case is still ongoing, and the question in that case is, when you win an administrative determination that you can't be evicted from a nursing facility, what happens next? Who is supposed to help you get back into that facility? And the state of California is not provided an answer other than, I believe they've said, you could go into court and file a lawsuit, which unfortunately takes a long time and, is not practical for a resident who is in a hospital waiting to go back to the facility that they've been living in for a long time. Next slide. And finally, Talevsky is the most recent case in this trio. And this is a lawsuit brought by a resident's wife against a county-run facility for violation of her husband's rights. And in the beginning, I think she had a whole host of rights that had been violated, but by the time it reached the Seventh Circuit, her allegations were just that her husband's rights had been, with respect to being free from chemical restraints, and his rights related to transfer and discharge procedures had both been violated. There was an amicus brief filed that our office participated in, that LTCCC and others participated in, that argued, for the court, just the important role that private lawsuits play in filling the gaps left by government enforcement and in compensating residents when they're harmed. And so, again, in this case was limited to the rights, the list of enumerated resident rights, but it said Congress clearly intended that section to benefit residents. Nothing in the statute is vague or ambiguous. It says facilities must not do what Talevsky alleged had been done, and again that must language was mandatory, and so that case has been sent back to the district court for further proceedings. And so that is sort of the overview. I guess I will take questions if there are any now.
Meryl, thanks so much. That was interesting and just so thought-provoking as well. I have a couple of slides just with some resources, and then we're going to open it up for questions, but I'm going to use the host prerogative and ask you a question myself.
Yeah.
With the Anderson case, and that was the one related to resident dumping.
Yeah.
I was wondering if you could talk all about like what impact, because it's a federal case, but obviously related to California, the California Department of Public Health not ensuring that residents' rights not to be dumped were being implemented, whether that would have a national impact, for instance, on residents in Florida or New York or wherever.
Yeah, I think it could. I mean, so in California, there's the Department of Health and Human Services, and then there's the Department of Public Health, and they both have responsibility for ensuring residents' rights are upheld. And so one of the agencies, I think it's DHHS, I'm not positive, but one of the agencies is responsible for the actual hearing process. But then when it comes to, you get an administrative decision, who goes to the nursing home and says, you have to let this person back in now, there's a void. And so I could see if that void, if that void was allowed to continue, that would create a hole that other states could follow. And conversely, if there's a decision that says, this decision does say you have to have some kind of mechanism for enforcing this. And so I think, you could use that in other states to say, well, it's not enough to just hold the hearing and give me a decision. You have to actually do something about it. And that kind of makes sense, right? Like what does the decision mean if nothing can be done after that? So I think even this decision could be used nationwide for that purpose now. And I think whatever the outcome is, could be used as a model in other states who have a similar problem. I don't know of any off the top of my head, but.
Thanks so much.
Yeah.
So I was just going to just wanted to piggyback a little bit on what Meryl was talking about today with some resources that may be useful to you and the attendees and the people that you are working with. These are all resources at nursingHome411.org, our website. So we have a learning center, as I think many of you know. We have recordings. This webinar will be up by the end of the week, but recordings of the previous webinars. As Meryl said, we did a webinar a couple of months ago on resident dumping. We also have fact sheets and resources for families and ombudsmen, dementia care advocacy toolkit, some really great podcasts, et cetera. And then I just wanted to quickly show also that we have actually a whole page dedicated to abuse, neglect, and crime reporting. So that includes a program that we did last year with someone from the New York State Medicaid Fraud Control Unit and Deborah Trahowski, who is an attorney who works on resident neglect cases, as well as myself. But we have here links to all the state agency contacts and complaint forms nationwide. We have a link to all the state Medicaid fraud control units. For those of you who are not familiar with what the Medicaid fraud control units or MFUCOs are, they every state has a MFUCO, and they are charged with addressing. They're charged with addressing, of course, fraud in Medicaid services, but they also, every state MFUCO has a complaint line, and they address abuse and neglect, or they're supposed to. So we have information on that and contacts for that, different legal definitions and other things, resources to help you, including forms and tools for resident-centered advocacy, et cetera. And then lastly, I just wanted to show one of the fact sheets that we have. Meryl had spoken a bit about pressure ulcers and about other nursing home services. And this is an example of one of our fact sheets. We have dozens of them. All but one or two are 2 pages front and back, so you could easily print them out, bring them with you to a facility, use them for family councils or resident councils. And very quickly, each one of them, as you can see on the left-hand side in purple, has a descriptive topic, as well as you can see here 483.25. That's the federal code that it's referring to. And then the F number, that's the F tag, F685 here, that's the F tag. So we include the code, so you can see, as you saw it in Meryl's presentation, she often cited the code, because as I will often say when I used to go in person before COVID to do a program with families or residents, it's not just that some bald guy came in and said, oh, I have these rights, is that you can say actually the rights go back to a portion of the code. And the reason why we include the F tag in every one of these fact sheets is because when, as Meryl was talking about, the oversight, the state and the federal oversight is really essential for ensuring quality of care. When a nursing home is cited, and as Meryl said, everyone is entitled to view the facility's inspection record, their survey report. If you see that your facility has been cited, the type of citation, the violation will be marked by an F tag. And this way you can connect, if you see, say, F676 on your facility's deficiency statement, you can go to our website, look that up, and you can see it's activities of daily living, what we have here on the right-hand side, the back side of the page, that was related to activities of daily living. And that can be useful for your advocacy as a resident, as a family member, or working with them to help them to both address those issues in the facility, but also if the facility has had a violation in that area, to understand what the facility is supposed to be doing to correct that issue. So I just wanted to very quickly mention that. A couple of items that are new at Nursing Home 411. We have a new podcast out, what 100% staff turnover means for nursing home residents. It's really good. I listened to it over the weekend. A new data report on what that found that 1 in 6 U.S. nursing homes is a quote unquote problem facility. That's a national data report. Our new Elder Justice newsletter, our last webinar in September, which was with David Kingsley, the hidden profits behind poor nursing home care. And we are just updating the nursing home COVID vaccination and facility data right now. So we're going to open it up for comments. As you can see here, if you're an long-term care ombudsman and your program supervisor allows you to get credit for attending this program, you can take the quick survey at surveymonkey.com/r/LTCCC-LTCOP1. This will be on the slides on the website as well, in case you need to write that down. We have about 10 minutes for questions from Meryl. So Haley or Eric, if you can look at the Q&A and we could choose ones perhaps that are a little more general for people, that would be great.
All right, I'll ask a few. We'll try to get to several of them.
Thanks. I'm going to stop sharing.
Right. We'll start with we'll start with Michelle's question. Are state-run nursing homes required to have accessible to residents and the representatives the policies and procedures used to run the facility. It is, we don't have to show you the policies, an appropriate response.
Yeah, I don't think that's an appropriate response. And I also think, I saw there's a couple questions. This talks about state-run nursing homes, and I want to be really clear. The Nursing Home Reform Act applies to all nursing facilities that participate in Medicare and Medicaid. So that includes even privately run nursing facilities, and the government enforcement piece that we talked about at the beginning applies to essentially all nursing facilities. There are very few that don't participate. It's only that private right of action piece that only applies to state-run facilities. And there might be other ways that you could sue, specifically, like if there's an instance where someone is injured or passes away because of poor care, right? Those are different kinds of lawsuits under state law and other laws. But to answer your immediate question, the policies and procedures used to run the facility, no, that's something that you should have access to.
Thanks. And here's one. Would it be more productive to earmark fines assessed on correcting the situation at the nursing home? So setting aside the money for providing service to the residents.
Yes. So I don't think so. And actually what I'll say is, it would be more productive for the facility to not, go out of compliance in the first place. They could proactively spend the money to provide quality care to their residents in the first instance. I will tell you though that on the back end, right, fines that are assessed, there is something called a civil monetary penalty fund that is used to provide grants that improve resident care. And so the money that is collected from the fines is used in that way. And so I know during the pandemic, at least some of those funds were used, for example, to provide iPads or other types of devices to allow residents to have visitation, virtual visitation. But they're even in non-pandemic times, that money is used to provide, services and things that benefit residents.
Thanks. And Richard, I noticed you had a strong reaction to the question. Anything you want to add there?
Oh, thanks. I would just quickly say two things. One is we don't want to, in fact, reward facilities for poor care. So if you turned around and you gave that facility or supported better care in that facility directly, then to me, it's kind of a slap in the face to the residents whose poor care led to the fine in the first place. I have pretty strong feelings about that. But I would say the other thing I want to add is I think we have materials on this on our website, but we've done a lot of work over the years with the levying and use of civil money penalties. And there's been some poor funding for poor uses of the CMPs over the years, but there's actually been some really good ones. And those monies can be used by residents and family members and advocates for them, and including ombudsmen. So there's a lot of different ways in which those resources can be used to improve nursing home care and quality of life for residents. Thanks, Eric.
Yeah, and here's a question from former webinar guest presenter Kathy Uncino. Although the Nursing Home Reform Act requires that nursing homes promote residents' highest practicable level of functioning physically, there are a few opportunities for residents to exercise, and as a result, they decondition quickly. Most, if not all, nursing homes are not in compliance with this requirement. What can be done to enforce this requirement or increase Medicaid rates so that both exercise equipment and adequate staff can provide this service?
Well, I mean, I think in terms of enforcing, one thing you can do is file complaints. So if you have a specific instance in a facility or residents that want to be exercising and can't or aren't able to for whatever reason, then you can complain about it. I think some more informal ways to ensure compliance with those regulations are, you can use their resident groups that could advocate for exercise time or specific equipment or anything like that. When it comes to Medicaid rates, this is sort of venturing into an area that's not totally my lane, but I do understand that, at least with respect to physical therapy, the payment model has recently changed, and there's an emphasis on group therapy now versus individual, and my basic understanding is that there has been decreases to the reimbursement rates for those types of services, and that is, maybe Richard knows more about that, but that's advocacy work, and doing the work with Medicaid to get those rates increased.
Yeah, just very quickly. I mean, the rates for the Medicare portion changed, and the way in which the rates are calculated changed from a per therapy service. This is very dumbed down, so to speak, but from a per service payment to an overall payment called the patient-driven payment model, PDPM is how it's called if people wanted to look it up. And so nursing homes now are paid a certain amount for each individual. Say, for instance, I'm 58 years old and I went in for a knee replacement. It would say start me at $700 a day, and then after a couple of weeks or a couple of days, whatever, decrease me, as it was expected that someone of my age with my needs would need less care. And as a result of that, this was just 2 years ago that this was implemented, the end of 2019, that we saw an immediate drop, as Meryl was talking about, in the number of physical therapists, occupational therapists, et cetera, and more of a move towards group therapy. So it's always been issues, frankly, with the industry trying to kind of finagle how to make, frankly, the most money off of providing, the least amount of services. But it does become an advocacy issue because residents, no matter whether they're Medicare or Medicaid, are entitled to the services they need, as Meryl said at the very start, to attain and maintain their highest practicable well-being. It's not it's in the law as well as in the rules. I think we have time for another question.
Yeah, we have time for one more. In our state of Alabama, and I suspect this might apply to other states as well, lawyers are telling plaintiffs that they are taking no wrongful death or abuse cases because the government signed an immunity bill. How can there be oversight now?
Yeah, that's a big problem, and it's not just in Alabama, it's all across the country. There are immunity bills, some of which were on the books for many, many years that were just activated during the time of the pandemic, and others that were passed specifically once the pandemic began. I think it's a huge problem. I think we talked about all the reasons why government enforcement is not always fully responsive to the needs of residents. It's not fully capable of protecting residents and ensuring quality of life. So, you need that ability to sue in order to, vindicate people's rights or be compensated when there's poor care, and also it's a transparency issue, right? If people aren't allowed to sue, it's hard. If I'm, looking to see if my family member should go to a facility, I want to look and see if they've been sued. And if that's totally foreclosed, then it's hard for me to know what's going on at that facility. So it's a big problem. I will say, I don't know specifically about Alabama's law, but I know that many of the immunity laws that were passed around the country, I actually believe AARP has a database that lists a lot of these laws, but some of them are limited in time, some of them are limited in scope, some of them have exceptions for when there is willful and wanton conduct. Some of them have to be very specifically tied to the provision of COVID-related care, and a lot of facilities were not engaged in that. They were simply engaged in normal infection protocols that they were supposed to have been complying with even before the pandemic. So, there are some situations where you can get around those laws, and that's one bright spot. But yeah, they're a big problem.
Meryl, thank you so much. This was really excellent, and I found it informative. I know our audience did as well.
Yeah, thanks for having me.
Sure, thank you. Thanks, everyone. Thanks, everyone, for joining us. We'll see you next month. We hope we'll see you at our November 9th program as well. Bye-bye now.